Right, everyone, morning and a warm welcome to another CISOS webinar. You will be delighted to know that you're not going to hear from us, the CISOS team, this morning. We have invited an expert in building compliance to come and talk to us this morning. It is Mr. Aubrey Snyman. If you don't know him, Aubrey, wave to the clients.
Can you see me?
Thank you, Aubrey. We can see you. Aubrey, thank you very much. This has been long overdue. The people present here this morning, and they will come in, as they come in. It's for internal stakeholders, that is the CISOS colleagues this morning, as well as for external stakeholders that we've invited to the session this morning. Unfortunately, with Teams, you can't invite more than a certain number of people. So if there is a need, we would advise to have you on board again with us to speak to a different group. I mean, we have over 1 million property owners in South Africa, and you can imagine that building compliance is super important. So, ladies and gentlemen, without further ado, just a couple of house rules. Please mute yourself. You can post your comments or queries or questions in the chat box. You can also ask a question afterwards. There will be sufficient time for Q&A. We're not going to rush the session at all. Please, can we not interrupt Mr. Snyman during his presentation? I know there's burning questions that we all would love to ask, but can we hold it for later? So Aubrey is going to talk to us about everything and anything about building insurance, how to be compliant, what information you need to be compliant. And I mean, we deal with it on a daily basis, so we are really looking forward to it here at the CISOS. Aubrey, the floor is yours. Thank you.
Thank you, Jolene, for the opportunity coming here from Cape Town today. And it's nice to see some familiar faces that I've met lately. And we're going to, in a short period of about 40 minutes, just trying to give you a brief introduction to the concept of building compliance. It's unfortunately, as Jolene said, it's a part of sectional title that have been neglected for quite a while. And it is quite integrated, and therefore one needs to really understand lots of things that's not normally part of sectional title, but we're just going to try and do it as simple as possible to connect the dots between all the different properties, all the different issues that we need to deal with. Now, the topics that we want to discuss that we hope to give you clarity on would include things like what is building compliance, the information required to determine building compliance. So we will go into how the establishing of compliance in the complex and just give a bit of background of the non-sectional title things mostly that affect a sectional title complex and the compliance of it. So the first question obviously is, why is building compliance in sectional title schemes important? Now, the very easy answer is it's a legal requirement. Various laws exist that make it a necessity to be compliant to all building regulations, basically. And the purpose of that is, of course, including protecting the value of the investment of each owner in a complex. And the purpose of building plans, the basic purpose is safety of the owners and the occupants. And then, of course, from the trustee side, it is the fiduciary duty to ensure that the complex is compliant. So the trustees don't have the privilege to decide, that's okay, we're not going to bother. And often, unfortunately, over many years, this attitude was followed, and today we sit with a huge percentage. I'm almost sure I can say 99% of complexes that is not compliant, and the longer compliance is not adhered to, the more difficult it becomes to fix the problems. And then a very important aspect as well that's often overseen is the insurance requirement. It is possible that you can have your complex insured, and when it comes to serious claims, it may not be paid out because there were certain compliance issues that was not complied to that created risk. Then in a complex, in community living, basically, normally you live in close proximity to your co-owners, and therefore what happened in one unit or section affects your co-owners that's close to you, and it will affect the quality of their life. And then lastly, but I think important, in South Africa, we want politicians to do things right. We want other people to do things right. But in our own complexes, we do not follow the same motto. And therefore, it's just the right thing to do to ensure that the complex is compliant. So let's just go to the next slide. And for the purpose of this session, we're going to look at a complex, a fictional one, Sample Park. And we just, for ease, we have 9 units in it. 8 of them is 100 square meters in size. 1 is 200 square meters in size. And then there's a pool and the garden walls and stuff. So we'll refer to this example a few times just to have a practical example, and you can obviously look at your own complex and see how this will affect you. Now, one of the biggest issues that we find over years in the industry is that there is confusion between the different type of plans that form part of a sectional title complex, plans that is required. And therefore, we're just quickly going to look at the basic 3 types and make sure that we understand the difference and why they are all important and where they come from, and why you need to make sure that they're updated. Now, the first is what we call a site development plan. Now, each property will have a zoning certificate, and zoning just basically refer to what type of land use is allowed on the property, and then how much of it, for instance. Now, that would be density, and that would give you the total amount of units that is allowed in your complex. So it would be referred to as 20 units per hectare, for instance, or 40 units per hectare. And depending on how big your property is, there will be a specific amount of units allowed. And that is all dealt with in the site development plan that must be submitted to council as a starting point for a development. Now, the implications of that in practice, what we see is that there's a maximum. Let's say you can build 25 units. Now, we often get requests, or we see on site where there was, for instance, outbuildings that were supposed to be toilets and facilities for gardeners is converted into a living unit that is rented out by the trustees, and they get income from it. Now, of course, that will make the complex illegal because you will exceed your density of the amount of units, and that can also affect your insurance and things like that. Then another point that is covered when you submit the site development plan, and it comes from the zoning certificate, is coverage. Now, coverage refers to the total amount of roofed area in the complex, and that would be in a percentage. It would, let's say, 30% coverage, and that means you can have 30% of the total area can be roofed. The problem comes in when the developer normally use most of the coverage that is allowed when the complex is erected, and then people start adding roofed areas like carports, and they enclose patios that never had a roof before, and certain other structures that's added, lapas, wende houses. Now, at that point, I must just state that in different councils, there might be slightly different interpretation of what they would consider as coverage. Uh, and therefore, it's important to just confirm with your local authority which structures they do include. But mostly, it's all roofed areas that have a roof on it. And therefore, one needs to be aware that trustees just can't give permission for any structure to be added if you are not sure that you have enough coverage left. Then floor area ratio. It's more applicable in multi-story buildings, because that include all the maximum of allowed bulk in the building. It is affecting the enclosure of patios and balconies and things like that. Then there's obviously height restrictions. That is not often a big problem, but one issue that is dealt with in the site development plan is the parking requirements. For each property, there's a minimum parking requirements that would be set out in the zoning certificate or in the town planning scheme. And big issues come about, especially when, for instance, garages are enclosed, and those garages form part of the minimum parking requirement. That will make the whole scheme illegal, because there will not be enough parking. So that is the first plan. So whenever a new development is done, that's the starting point, and that plan must be changed every time when new additions or alterations is undertaken, and should always be updated. And my feeling is that that is the responsibility of the body corporate. So they should always have the latest up-to-date site development plan available. There is unfortunately very few complexes that have this, and it's also, there is certain properties where this would not be a requirement immediately, but council can, whenever you submit building plan, ask for one. Then the next one. Okay, we have the sample one here, just to show that the typical zoning, the typical site development plan will include all of these issues that we're going to deal with. And over here we just have an example of additions that was made for the coverage purposes, just to explain the concept, where we before had the, as I said, we have 20% allowed coverage, and that will work out to 5,200 square meters. Now, after all the units was built, we were close to that. Now, by adding, for instance, 2 carports to it and a lapa, not huge areas, you will already exceed the coverage. And therefore, it is important to always understand what the situation is about the coverage that you have. Now, as far as building plans is concerned, building plans is required in terms of the national building regulations. And the purpose of building plans is not only a nuisance factor, it is for the safety of owners and occupants. And unfortunately, from time to time, you will recall we hear about buildings that collapsed, where people were killed. We don't always hear about the small instances in complexes where carports collapse or a storm blow off some of the roof material and people get injured or damage to properties caused. So the purpose of the building plans is for the safety of all owners, and therefore the trustees have a responsibility as well, and the body corporate, to make sure that the complex is safe. Now the question is always what structures needs to be on building plans. And it's fairly easy. The law states that all structures, permanent and temporary, needs building plans. So that will include all inhabitable buildings. It includes garages. It includes carports, patios, that's roofed obviously, lapas, pools, windy houses, and my easy explanation is anything that you can't pick up and put in the garage when the building inspector come and do inspection needs a building plan. Anything higher than 1.2 meters for that matter, so up to 1.2 meters you can still get away with it if it's just a wall or something like that. Anything else needs a building plan and should be on a building plan. Now, one issue with building plans is that people often say, but the council lost my plans and it's their problem. Unfortunately, according to the national building regulations, it's not the case. It is the responsibility of each owner to have a copy of their building plans and their certificate of occupancy at any stage. Council don't have to keep building plans, and therefore you can't go to council and say, you've lost my building plan, so you need to fix it. It is important that each owner understand it's their responsibility, and it is the responsibility thus of the complex as owner of the property or the common property to ensure that they have a site development plan that is up to date. Any additions that is done after the original building plans was approved obviously needs to be added to the building plan, and new building plans must be submitted, and it is the responsibility of trustees to ensure that that is done. Then the third set of plans, and as I said, we often get confusion where people say, but you know, we have plans. When we ask them for building plans, do you have? Yes. And when they send it to us, we see it is sectional title plans. Now, we said that building plans was in accordance with the national building regulations. Sectional title plans required is only about ownership. It have nothing to do with safety. It have nothing to do with building regulations. It's a totally different set of plans that's only purpose is to indicate ownership. So you won't find ownership on a building plan. The building plan will look exactly the same for a complex that is owned by one owner that's not a sectional title, or for a complex that is sectional title. The sectional title plans make the difference, and that indicate who the owners are. So what is indicated on the sectional title plan? It's obviously the sections themselves. It is common property. It's exclusive use common property area, because all exclusive use is still common property. It will give you the participation quota, referring to the percentage of the sections that you own. And from that, it will be determined what contribution you make in terms of the levies. So, and then there's also what we create often when exclusive use areas needs to be created in the rules. Um Exclusive use plans can be created, and that will form part of your rules eventually, but we'll talk about that a bit later on. Now, the sectional title plan, as we said, we have all those different issues that's indicated, and let's just go to the next slide and the sample of what it all referred to. Firstly, we said the section. Now, a section is indicated on the sectional title plan of the scheme. It is demarcated with solid lines and has a section number attached to it. The section will also have a square meterage attached, which is important for calculating the levies eventually. It is calculated on the participation quota of the section. So that is the section part. So let's go back to common property. The question is then now, what is common property? And there's lots of misunderstandings about common property and exclusive use. So common property is the rest of the buildings and the ground after the section have been removed. So the orange would be the sections, the rest will all be common property. But common property is more than this. And if we look from above to a complex, you will see that the next slide will indicate really what is all common property if you look from the top. Technically, everything would show as common property because remember, the roofs as well as the outside walls form part of common property. The section ends in the middle of the outside wall. So anything on the outside of a section, including the roof area, is all common property. And that have an impact when you want to attach anything to a wall or to the roof. And we will have a look at solar panels and those things just a bit later. So in fact, one must understand that you only own the inside of your unit. Even when there's exclusive use areas registered, it's still common property, and it need to be dealt with it that way. So common property is essentially the physical ground on which it is, plus the roofs, plus all of that. So in the sectional title plans, you should all know this and have seen it. The first page would always be the block plan, and the block plan gives an indication and it depicts the position of the buildings in relation to the earth boundaries and other real rights. Things like servitudes will also be indicated on the plans, and it's obviously important, and I haven't said that before, that each complex should at all stage, either the managing agent or the trustees or both, be in possession of all these plans, starting with zoning certificate, because that is the basis where you're going to work from when you look at additions and alterations. Then the site development plan, then of course the building plans, and then the sectional title plans. It makes life so much easier for everybody if those documents are kept safe in one place, and it is possible for the managing agent or the trustees to deal with any issues because they have the documents available. Then the floor plan would be the second page or whatever of the sectional title plans, and that will indicate the graphically shown how the different sections in common property relate to each other. So the inside of the blocks would technically be the sections. Anything else would be common property, to just make it very basic. Of course, it will also indicate exclusive use areas if it was registered via the land surveyor. But important to note that to have exclusive use area, it needs to be in a document, either in the sectional title plans or in your rules. The fact that you have a garden with a wall is not an indication that that is your exclusive use area. There's a huge misconception that we often get where people say, no, but it is my exclusive use because it's inside my garden. You need to ensure how that was allocated as exclusive use to you. And if you don't have proof or it's not in documentation, then it is just pure common property, and you are not the owner of it, or you have exclusive use of it. Okay, and then the last page, and the important page as well, especially when it comes to additions and alterations, is your participation quota in the last page. And that will give you the number of the section. It will give you the square meterage of your section, and therefore it will give you, from that, the participation quota is calculated and your levy is calculated from that. Just a point of interest, if you have a building plan and a sectional title plan for the same structure, you will find that there is a difference in the square meterage on the two plans. And often that is, people say, oh, one must be wrong. Keep in mind, we have mentioned that sectional title is measured from the middle of the outside wall, while a building plan is measured from the outside of the outside wall. And therefore, the area on the building plan will always be slightly bigger than the sectional title plan. It's not a mistake. That is just the way it's surveyed, and it's important to understand that. Now, we want to go back to our example and just show the impact on levies when alterations and additions are not dealt with correctly, because as we said, the size of your registered unit determines your levy. Now go back to our example. We have the 8 units of 100 square meters, one of 200, and therefore the PQ of each one will be 10%, and the last one will be 20%. And let's say the complex need 20,000 Rand per month. It's an easy calculation to do. Each unit will pay 2,000 Rand, and the bigger one will pay 4,000 Rand. But let's now see if addition is done to one of the sections and it is not registered correctly, how one addition can affect the whole issue about levies. And remember, if it's not updated, then levies are not collected correctly, and that's one of the fiduciary duties of the trustees and the body corporate, to ensure that that is collected correctly. So we just have one basic addition to Unit 8 of 40 square meters. So you'll see number 8, yellowly marked, will now be 140 square meters in real life. So the correct levies that should have been charged would immediately go down. The PQ of all the others will go down from 10% to 9.6%. So their levy from 2,000 Rand will come down to 1,920. And the levy of the Unit 8 that was extended will go up to 2,720 from 2,000. So you can see it looks like a small amount perhaps, but if this carry on for a year or two, other owners are subsidizing owners that made additions that should have become part of their PQ, and therefore there's subsidization happening. And that is not acceptable and not legal to really do that. And therefore, it is one of the critical things with additions and alterations is to ensure that whatever should be included in PQ is included in PQ. Of course, before the land surveyor can survey the addition, he needs to confirm that building plans have been approved for those structures, and therefore it is advisable where you have a complex with a few or lots of illegal additions, that all of that is dealt with simultaneously. It just make it much cheaper, and it otherwise it's every few months you're going to get a land surveyor in to survey another addition, and every time the participation quotas of all the units will change, because you will understand that you work to a percentage of 100. So if one increase, others will decrease. And therefore, every time additions is registered, everything change, and you don't want that unnecessary. So yeah, that's the important part of levies and additions. The other plan that we just slightly look at and just want to mention again is exclusive use plans. We advise complexes that do not have registered exclusive use areas to create exclusive use areas in their rules, and that would include things like the gardens, what people see as their gardens. It can be the washing areas at the back, carports, anything that is now common property but is seen or used by a unit or a section and perceive as theirs. And as I said, there's lots of carports and stuff built by owner that he believes it is his. Technically, if you build a carport on common property, anybody can use it. Anybody can use your garden. And we had cases where a person wanting to have a birthday party for her son walked through the complex, found the biggest and nicest garden, and had the birthday party there. And of course, it is 100% legal to do so because no common property exists, no exclusive use area exists, and common property is for the enjoyment of everybody in the complex. The same with your carport. The fact that you have paid for it doesn't mean that you have the use of it. So if you get home in the afternoon and somebody else parked in under your carport, technically it's quite legal. You have no foot to stand on to say it's my carport. That can be solved by creating exclusive use areas for your gardens, for your carports, and for any structures that that it's possible for, and that the body corporate deemed to be worthwhile. Of course, you need the buy-in of your co-owners. So you can't just say, listen, I'm going to register exclusive use for my garden, but we're not going to do it for everybody else, because you will not get the support that you will need to change your rules, and therefore you will not be able to register the exclusive use areas. On those plans, we need to indicate the size of the exclusive use area, and very importantly, what it will be used for. So typically we'll put in for gardens, And that doesn't mean that now you have exclusive use of the garden and you can now make additions and add structures to it and make all changes there to your liking. It just means that you have the exclusive use of it. So we recommend that the exclusive uses plans are created and that we add that into the rules with all the required rules to go with it, whereby you can control certain things like maintenance and stuff. But we're not going to go into detail of that now. The typical request, and we're just going to go quickly through a few of the typical requests that trustees would normally get. Carports, adding bedrooms, living rooms, sculleries, lapas, wendy's, enclosed patios, balconies, internal changes and converting garages. There's lots of misconceptions. And then just a quick word on solar panels. Okay, the first request is typically for carport. Now, we're just going to mention the aspects that you should look at, and we have discussed some of it. The first is ownership. If it's not, typically they are erected just in front of the existing garages or next to the entrances or stuff. And most of the time in complexes, that is common property. So as I mentioned already, the fact that you pay for it doesn't mean that it's yours. So therefore, the body corporate needs to determine how we're going to deal with the ownership of that. And that's where we suggest that the exclusive use areas is registered. But then remember, the site development plan deal with things like coverage and access, entrances, exits, and making sure that a vehicle that vehicles can move freely inside the complex, and that is approved in the beginning when it's designed before it's built. Now, any changes to that, of course, can affect some of these issues. And a typical issue that body corporates often do not think about is, for instance, when the design is done in the beginning, one of the departments that will approve it would be the fire department. And they will ensure that a fire truck can reach wherever it needs to, should there be a fire. Now, if carports are erected without considering issues like that, it might be that you can get cars past the carports and people's patient, and you wait for the one person to leave before the other one use the road. But should you need to get a fire truck in, it might be that those carports can prevent the fire brigade to reach the fire. In a case like that, of course, your insurance will or may tell you, listen, we insured you and the risk was not that high because, firstly, it's brick and tile, it won't burn easily. And secondly, the plan was developed in a way where the fire brigade can reach. Now you have erected structures in its way, and so we are not going to pay out your insurance claim, or we're just going to pay out a portion of it. And therefore you put the whole complex and the owners at risk by just allowing people to add stuff without considering all of these issues. So, of course, the building plan need to be updated. Building plans need to be approved for carports, and then you'll need the engineer certificate to certify that this is going to be safe. And most importantly, the fact that the building plan have been approved doesn't mean that the construction was done according to the building plan. So that's why inspection will be required by council and the certificate of occupancy being issued for all structures. Important to understand that the building plan is an indication of what the owner intends building. It doesn't mean that that is what was done. And we had cases where plans was approved with all the foundations and things, and eventually the construction is not done that way. We even had cases without foundations where people just decide it's too expensive to build the foundations and they just build on top of the ground. We had cases with toilets, for instance, that is not connected to the sewer system, and that all create problems. So although it's indicated on the plan, it doesn't mean that it was done that way. Another one that we want to look at is the typical request when buildings is added, like for additional bedroom, living rooms, or a very popular one that is very problematic is enclosing courtyards. Now, enclosing a courtyard, firstly, may have coverage issues because you put more roofs on, but then mostly the biggest problem is ventilation, and often, most of the time, there's a gully in the courtyard, and that cannot be enclosed because you have ventilation issues, and the purpose of a gully is that it must be able to ventilate, and also you create quite a lot of risk, including fire risk, by doing that. There is various interpretations of by council of exactly when they will see it is 100% enclosed. Sometimes we see that people leave a little space between the roof and the walls and say, no, but that's fine for ventilation. It's not. You need to confirm that by approved building plans and by a certificate of occupancy for that. Now, in cases like that, you obviously also need the site development plan change, you need building plans, you need the certificate of occupancy, but you also then need to change your PQ, because that becomes part of your unit, and the maintenance of those will eventually and should go to the body corporate so that it can be done consistently with the rest of it. And therefore, after construction, after approval, if you can get it approved, and as I said, it is problematic, and we often see enclosed areas at the back, even where there's municipal manholes for sewage and for stormwater. Now, of course, that can never ever be allowed, and council will never approve a plan. The problem is if body corporate and trustees just leave those things, it just become more, because if one is tolerated, then the next guy, you can't say no to him, and eventually you might get to a point where 20 or 30 people might have to remove the roof. So it's advised that as soon as things like that start occurring, it's dealt with, and see if it is possible to allow it. Ventilation is a huge problem. And then, of course, if the PQ is enlarged, then the levies will change, and the steps must be taken to increase the PQs and the levies. Problem areas as well often is things like Lopers and Wendy's, often also built on common property. And the problem is that when an owner erect it and use it, he will claim it as his. As soon as there's a problem and there's a fire and there's huge implications, he would just say, no, it's common property. And he will be right. It is common property. And then you sit with a legal issue. So again, when those things are considered, and my personal opinion is that things like Wendy's do not belong in complexes. You must ensure how you're going to deal with ownership, exclusive use areas, often again one solution. And then, of course, it must go onto the site development plan. You need building plans. It can never be used when the houses are not suitable for human habitation. It can only be approved for storage. And then, often as well, it is placed in servitude areas. Each property may have one or more servitude for municipal services, and structures are not allowed to be erected in those servitudes. And then for both Lapas and Wendy's, fire consultants is required because it is a fire hazard. Those structures are not made of wood, of brick and tile, and normally that's what your insurance will insure you for. So make sure that you are covered in case a fire would start in any of these structures. Of course, they need to be legal, they need to be on building plans, they need to be on the site development plan, and there must be ownership must be sorted. Who is it? Is this common property, or is it exclusive use area, and who's responsible? And if it's exclusive use area, there should be rules dealing with these type of things. But as I said, it once you start allowing these type of structures, it is very difficult to really control them, and it is accidents that wait to happen. Um, Okay, then enclosing patios, same issue sometimes. Often patios are common property. You must find out, is it part of the section already? You also need to have approved building plans, the construction certificate of occupancy. If the PQ must increase, the whole process of the land surveyor. And very important, there should be specifications to have consistency in enclosing patios and balconies, to make sure that visually you have a similar appearance, and to make maintenance in the long run cost effective and practical. And therefore, it is important for the trustees to have guidelines for this and set up specifications to prevent each owner from just doing it in his own way, affecting the value of the whole complex eventually. We're just rushing through the last few ones, the most important that we already discussed. Internal changes and garages. There's a misconception that you don't need plans when you make internal changes. Whenever you make changes to the sewage system, or change bathrooms and stuff, or remove and change walls, you do need building plans. Um, Removing walls can become a problem for the body corporate, because we had cases where the roof will collapse if you remove a load-bearing wall. And of course, the roof is then common property, and technically it becomes the problem of the body corporate, and therefore it must be emphasized that building plans are required as soon as you make any structural changes to the inside. The big issue, the elephant in the room, is converting garages into living areas or bedrooms. It should not be easily considered, purely as we said. Those garages were set aside for parking. You're not allowed to use any room for other use than it was approved for on the building plan. and it will affect your parking requirements. If that was set aside for owner to park, you can imagine if he don't have that to park his car, he need to park somewhere else, and that would be common property. Common property is for the enjoyment of all owners and co-owners, and therefore, technically, he will have to park his vehicles outside. He can't just park in front of his garage. That's not his. And otherwise, there must be a method found whereby he can reclaim some parking, even if he must buy it, or but it must be registered. And important is to consider it might not be problematic when you have one owner doing it, although you might not get permission from council. But if you allow one person, you cannot say no to others. And imagine if you have 50 units and 50 people decide we enclosed our garages, where are they going to park? It will create chaos and it will devalue the complex seriously. So full procedures need to be followed if you want to approve it. There's the very well court case. I think that was very clear, the High Court case that where it was determined that these type of things cannot just be done, and the procedures need to be followed, but it should not be encouraged to do that. Now, the last point we want to look at is solar panels and anything on the roof. As you've seen, the outside, the roofed areas, the walls is common property. So one way of dealing with it is also to register exclusive use areas on the roof, and therefore it can be then put in the rules who's responsible for all the complexes. I know it's almost time for questions. Just quickly, how do we know if our complex is compliant? We undertake complex audits, and a complex audit is a way to find out what is the difference between the legal situation and what's actually in the complex. Just the example of one plan, everything in red was added illegally. So you can just imagine how it affects the PQs of the units. The last point, and that's the most important that I want to make. When trustees or managing agents give permission for any alterations or additions, please just state that it's always on condition that the provisions of the Town Planning Scheme, the National Building Regulations, and the Sectional Title Act, Management Act, and all the rules must be adhered to. Don't just write a note and say approved or we have no objection. Just give them the full spiel so that they don't see trustee approval as the final point, because trustees can never give any permission not taking all other rules and laws into consideration. We're running late a bit, but it's time for questions. Jolene, I don't know if you want to, if there's any questions, please give it to us. Sorry for running a bit late, but it's just so many stuff I like to share.
Thank you so much, Aubrey. No, definitely. I mean, we wouldn't mind going 5 to 10 minutes over time. This is extremely important. Before we allow for questions, I'm going to ask you, Aubrey, if you can provide the CSOS with an example of a site plan, a site development plan, a building plan, as well as sectional title plan. You can take out the specifics and all together with your presentation and this recording that we are going to share with all our clients on our database. And then can we have the permission to share this email address with them as well then?
Yes, you're welcome to, and they're welcome to send
Awesome.
us mail, and we will try to answer them as well as possible.
Awesome. So let's go to the chat, Aubrey. I'm going to just start from the bottom. I always start from the top. So Michelle is asking, if you don't have these plans, where can you get them from?
Very good question. Sectional title plans is available from the Surveyor General website. It's a bit tricky, but they can also ask us. We can assist them to find that for them. Otherwise, you need to go to the Surveyor General's office. But again, we can assist them with that in most cases. Building plans, of course, you need to go to your local authority. And if they don't have a copy, the bad news is you need to start from scratch. We often do what we call as-built plans. So if there's no plans available, we go and we survey each structure and we submit it as if it's going to be built. That is what council require, and you need to get that approved, and you need to get all the certificates for council to issue your certificate of occupancies. As we said, people don't understand, but it was their responsibility to get those plans when they bought into the complex. Now, unfortunately, for years, estate agents didn't want to take that responsibility, and most properties was just sold without those documents going from the seller to the buyer. But that have mostly ended now, and most buyers now will insist on it, because the moment that it transfer in your name, you become the owner of all the problems. Council is going to ask you for plans and not the previous owner. So yeah, that's unfortunately the reality of it.
Sure. Thanks, Aubrey. Another question from Christopher. What happens when the developer did not get the building drawings approved by council, but a COC was issued?
Yeah, there is a bit of corruption is unfortunately everywhere. Eventually, it is again the owner's responsibility to have approved building plans. The fact that the COC obviously only refers to the electricity and not to the whole building. But the building inspector, if he come and inspect, he needs a plan to compare the buildings with. So you can't ask him for a certificate of occupancy if you don't have plans. And he don't have plans, because the certificate of occupancy states that what was approved on the building plan is what was built, and according to that specifications. So he have nothing. He can't just come out and have a look and say, this looks fine. He needs to have a plan, and therefore that's where if you can't locate plans, and sometimes you can, if you still can get hold of the developer or his architect, they might have copies of the plans. But again, often they didn't build according to what they had approved, so they don't want those plans to be circulated.
Thanks. Safiso has a question. I'm a trustee of a body corporate in Midrand. The sectional title scheme was registered in 2007, and plans were approved. And now we have an issue to extend our security wall by 90 centimeters, and the new size will be 3.49 meters. Do we need approval from council to add new lines to the wall so that people from the outside can't jump into our complex?
Yes, well, jumping over a 3-meter wall is quite something, but yes, you do. And you also need, for that height, you obviously need an engineer certificate, because that is quite a high wall. And you need to ensure that it is safe. So there will be a design specification as far as how many rows you can add. It might be that you had to add more pillars to it, or put some other reinforcement into it to make sure that it is safe.
Thanks, Aubrey. I think another question I'm seeing here from Doug. Will a material deed of cession on an exclusive use area remove it from common property?
No, it never removes it from common property. It always common property still, but it gives the owner the exclusive use of it, but it's still always common property.
Thank you. There's two more, and then we can take some questions from the floor. Eben, what is the process if a patio is added on the upper level over another space? Does the sectional plan change, or is it just registered as EUA?
Okay. The first thing that you will have to have a look at is the existing sectional title plans. Often or sometimes those areas are already included as part of the section, especially in the older complexes. They were often already, so you're already paying on it. So firstly, you need to determine, is it exclusive use area now, or is it part of the section, or is it just common property? We don't find many that's registered as exclusive use area. Now, again, there's a gray area when something like that is done. Our way of looking at it is whenever it is enclosed weatherproof, it is as good as the section. So if it's common property and you have enclosed it and it have a roof and it have windows and it's weatherproof, then there's no difference between that area and the rest of the section. In that cases, we are of the opinion that it should be included in the PQ to rectify the levies, of course, but it's for the body corporate to decide if they want to register all of them as exclusive use areas. Then it's much of a muchness because levies, everybody's levies will then be consistently, it will not be included. But you need to be consistent. So if you do it for one as including in the section, it must be done for everybody. If it's done as exclusive use areas for everybody, then again, it's fine as long as it's consistent. But if it's enclosed, I can see no reason why it's different from the rest of the section that is included.
All right, thank you. Last question in the comment in the chat box. Adele, I'm a trustee in a sectional title complex where you have mentioned approval in many cases. Does approval from authorities preclude how alterations or additions were arrived at in the first place, such as resolutions?
Sure. I'm not sure that I exactly understand the question. Perhaps just repeat it. Let me be sure that I answer the correct question.
No worry. Adele, can you please unmute yourself and
yes.
please ask the question to Aubrey? Thank you.
Hello.
Hi, Adele.
Hi, this is Rahul speaking in behalf of Adele. I'm her husband.
Oh, okay.
Okay, so nice. What I meant was we have certain situations in the complex where building plans approvals were all taken from the competent authorities. But how they arrived in order to acquire that piece of land is a big question mark. Let's say we needed a resolution. So because the plans were approved, does it mean that the resolution is not required in retrospect anymore? Does it give it any legal basis that they had engineer certificate, building plans, everything registered, but common property was transferred into somebody's exclusive use area and they did not arrive at it with the proper resolution held? They just had permission from 3 or 4 trustees, that's all. That is the question.
Okay, yes. I think that is more a legal question, and perhaps, Jolene, you are almost better qualified to answer that. It is a problem where council don't really always double check that the procedure was followed for them to approve the plan. They are not sectional title experts, and as long as they see some kind of a signature by trustees or whatever, they will often see that as enough, and that can create this problem. So, Jolene, perhaps you can just give the legal opinion on that.
Yeah, what I'm going to do, thank you, Adele's husband. I didn't quite catch your name, but I'm going to put my details on the screen. What we have done at the CISOS for you already, we have set out the different types of resolutions there can be in a community scheme. So I'm just going to give you my details quickly. It's at the bottom of this presentation. There you go. You can just pop me an email. If you don't have my email address, there it is on the screen, and we can go through that. I'm just going to take the final question, then we're done, ladies and gentlemen. It's from Caroline. Caroline, you can please go ahead.
Thank you. You kind of answered my question pretty well. Thanks very much.
Thank you, Jolene, and good morning to everybody. I think just more a comment with regards to building plans and procedures. There's a few gaps, and whilst you know, the council may, or the municipalities may not be checking that the correct resolutions, etc., were followed, there are specific requirements within their bylaws and their specifications in terms of ensuring that the correct procedures were followed. So, for example, in Cape Town, there's the BDM 03 form, where before they actually issue that certificate or their approval, there's a requirement that the chair signs that they state that all the relevant requirements of the STSMA and the Sexual Titles Act have been followed, and that there's no objection. There are instances where managing agents and trustees are submitting plans to council where there are various changes to common property as well as to personal registered properties, changes to which do not align to the Sexual Titles Act. The Sexual Titles, the schemes registered plans. And the councils are approving them, saying they've seen a signature, but there's also approvals happening where they are aware in advance of those approvals that the required resolutions were not passed. And then when there's an approach to, for example, the CSOS to attend to those matters, CSOS apparently, from my understanding, are not able to override the decision by council. So there's missing links in terms of the correct checks and the obligations to the trustees, ensuring that and the body corporate in terms of section 3(1)p of the STSMA and their function to ensure compliance with any law relating to the common property or to any improvement of the land comprised in the common property. So there's a lot of missing links, and I'm quite certain, or I presume, that there are many people in sexual title schemes where there are, in inverted commas, approved plans sitting at council where there are changes to not only unapproved or incorrectly authorized or incorrect changes to plans, but to their personal registered properties, which is a massive problem.
Yes, yeah, I must agree with that. Up to now, there's not really the link that is supposed to exist between building plans and sectional title plans. Council is not, they deal with so many stuff, and very few of their plan examiners, for instance, would be qualified to understand sectional title at all. So they just look if there's some signature or whatever. They have 100 other plans to deal with, so they don't really do the necessary investigation to find out that it was authorized automatically, and it creates problems later on, and I'm not sure what the legal solution is to that.
Yeah, thank you, Aubrey. Just from my side at the CSOS, we have jurisdiction over illegal structures and buildings as such. It's embedded in section 39(2) of the CSOS Act, where if there's an illegal structure or if anything is not done accordingly, you can come to the CSOS to lodge a dispute, and our conciliators and adjudicators will have a look at the matter. But on that note, Aubrey, I want to thank you very much for this informative session. I've learned quite a lot. I can't wait to receive all the documents and your presentation to circulate it to everyone. Keep a lookout on your inbox, because I'm sure it's going to be flooded after this, and so it should be. For our clients that could not be here today and that we could not invite, we're going to send it to our entire database, because I think it's vital that this information is out there in the industry and that we are transparent in the industry and saying we've got an expert in. He advised us on building insurance, what to look out for, So we are all compliant at the end of the day. And obviously to see less disputes coming into the CISOs on this very matter. So Aubrey, I want to thank you and your team very much for coming in today. I really appreciate it. And the meeting is now adjourned. Everybody must have a good weekend and goodbye.
Thank you, Jolene.
Bye-bye.
Bye-bye.
Thank you, Jolene.